It was a defining moment for both the electoral body and the opposition when 3 judges sat to give their verdict on whether declaration of presidential results should be done at the constituency or national level. And when the 5-judge bench turned up to issue the landmark ruling, their decision was unanimous that High Court was right in declaring results announced at the constituency level are final.
We find no fault in the determination of the High Court to the extent that Section 32, 39(2) and 3 of the Act and Regulation 87(2)(c) provide that the results declared by the returning officer are provisional, and to the extent that Regulation 83(2) provides that the results of the returning officers are subject to confirmation by the Commission, these provisions are inconsistent with the Constitution and therefore null and void. There is no merit in this appeal, which we accordingly dismiss.
Appellate Judges Patrick Kiage, William Ouko and Agnes Murgor, in a 4-hour judgment, the judges were equivocal that neither IEBC nor its chairman Wafula Chebukati has no legal powers to modify or alter presidential results once they are announced at the constituency level by the returning officers.
But there is no doubt from the architecture of the laws we have considered that the people of Kenya did not intend to vest or concentrate such sweeping and boundless powers in one individual, the chairperson of the appellant. The responsibility of the appellant to deliver a credible and acceptable election in accordance with the Constitution is so grave and so awesome that must approach and execute it with absolute fidelity, probity, and integrity.
The judges questioned why IEBC will doubt its own officers in declaring the results at the constituency level, if indeed they were employed in a transparent process.
It is as hypocritical as it is incongruous for the appellant to doubt the competency, proficiency, and honesty of its own staff as the reason for the need to verify the results to ensure they are not tampered with. The appellant has the opportunity, indeed a duty, to vet all his prospective employees to ensure they pass the integrity test before engaging them.
They were quick to state the provisions of the law that informed the decision.
Before he makes that declaration, his role is to accurately tally all the results exactly as received from the 290 returning officers countrywide, without adding, subtracting, multiplying, or dividing any number contained in the 2 forms from the constituency tallying center. If any variation or confirmation is anticipated, it has to relate only to confirmation and verification that the candidate to be declared elected president has met the threshold set out under Article 138(4) by receiving more than half of all the votes cast in that election and at least 25% of the votes cast in each of more than half of the county.
And while IEBC had questioned the jurisdiction of the High Court in declaring the constituency results as final, the judges were here also to set the record.
That the High Court had jurisdiction to determine the constitutionality of the impugned provisions of the Elections Act and the regulations made thereunder, and the fact that the first, second, and third respondents could arguably have raised the issues before the Supreme Court under its rules did not deprive the High Court of the jurisdiction vested by Article 163, Subarticle 3D. Accordingly, we are not persuaded that the High Court committed an error or assumed a jurisdiction that it did not have.
The judges also faulted the electoral body for reenacting the elections regulations through a gazette notice despite the High Court decision that nullified them. The ruling follows an appeal that was filed by IEBC seeking interpretation of an earlier High Court ruling that declared results announced at the constituency final. The respondents in the case included the opposition, human rights activist Maina Kiai, Khalif Khalifa and Tiroparap Kitur, who argued that it is at this point of national tallying that votes can be altered to suit a candidate, which could be a recipe for chaos. After 16 days of considering the appeal by the Independent Electoral and Boundaries Commission, the judges have given their verdict. What remains to be seen is whether IEBC will be satisfied with the decision or it will move to the Supreme Court to lodge another appeal.
We are pleased that now 8 judges independently have agreed with us that the Constitution is very clear, that results are announced at the polling station and they are final. There can be no tampering, no touching them, no so-called verification. So now it makes it easy for everybody in the country to actually pursue and independently do the tallying ourselves. So we can know at the end of the day who is the president, who's not the president. So no more of this keeping us in suspense for 7 days, 6 days, and raising our tensions.
We have now a total of 8 judges from the judiciary who have pronounced themselves on this. Why would they not be satisfied unless there is a specific result they want and for mischievous reasons?
Ben Chumba reporting for Channel 1 News Hour.